Hello, everyone, and thank you for attending today's webinar. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget on the bottom of your screen. We'll try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. If you experience any technical problems during the webinar, those can also be reported through the Q&A widget. A copy of today's slide deck is available on the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical questions located in the help widget at the bottom of your screen. Today's event is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to receive full credit. We value your opinions and appreciate your participation in the course. All right, I'd like to welcome everyone here. Today we will be walking through a private equity case study in the healthcare space. My name is Nathan Viehl. I'm a partner in Thompson Coburn's Corporate and Securities Group. My practice primarily focuses on private equity transactions, and I'm joined today by my colleague Raquel Boton, who's in our healthcare group. To frame today's presentation, we're going to present a hypothetical case study. All these parties are made up, but that highlights some very real trends in the healthcare M&A landscape. So a few months ago, Heartline Capital Partners, LLC, a private equity sponsor with $500 million in assets under management, began exploring cardiology due to factors such as an aging population, increased demand for cardiovascular care, and a shift in pay towards value-based care. However, Heartline was not simply looking to invest in any practice. They're looking for a well-managed group that could serve as the foundation for a broader roll-up strategy in the cardiology space. That brought them to Cardiology Associates PC, our target business here, which is a 12-person physician group that's attracted to buyer because it could serve as the foundation for this broader strategy. The practice generated approximately $35 million in annual revenue and maintained adjusted EBITDA margins of around $5 million. More importantly, it has a strong clinical leadership team, stable referral base, all of which made it an appealing investment to private equity. From the practice's perspective, this deal represents a strategic opportunity. The physician owners have an opportunity to partner with a private equity firm to scale their practice more efficiently, invest in infrastructure, and focus more of the physician's time on their patients' needs, while shifting some of the more time-consuming back office, administrative, operational tasks to a more experienced partner. So for the purposes of today, Heartline has approached us for our assistance in helping them acquire Cardiology Associates. And over the course of the next hour, we're going to walk through this case study step by step from the perspective of both inside and outside legal counsel supporting the buyer in the transaction. We'll begin with some of the key considerations in negotiating a letter of intent. Then we're going to turn to the business, regulatory, and financial due diligence work streams. And from there, we'll explore some transaction structuring and drafting considerations, and conclude with some tips on the drafting and negotiation of the definitive and ancillary agreements in a transaction like this. All right, so in the first stage of the transaction, the first thing that usually happens is the buyer, Heartline Capital here, they begin formal discussions with the practice through the negotiation of something called a letter of intent. This is going to outline the key terms of the deal, and we'll walk through all of these right now. But this is basically our roadmap for the rest of the transaction, and the goal here, these are typically non-binding terms, except for a few important ones, namely confidentiality and ultimately exclusivity. The goal here for Heartline is to get an agreement in place with the seller that they're no longer talking to any buyers. In other words, they have an exclusive negotiating window with our buyer. So as the buyer, we want to understand the situation, particularly if this is a competitive bid process. If it's a competitive bid process and the seller's marketing this business to multiple buyers, they may have hired an investment banker, or they may have otherwise indicated that this is a competitive process. We want to come in, get an LOI, lock in exclusivity quickly. The seller's goal is to push for a longer term sheet and more binding provisions, because from their perspective, they want to start to create, they want as much negotiation to take place during this bidding war as they can, because once they lock in with one buyer, they're going to lose a lot of leverage. So the first provision that's typically important for lawyers to get a handle on in an LOI is whether this is going to be an asset or a stock purchase. And it's important to know some general basics. In this transaction, it's almost surely going to be an asset purchase because of corporate practice and medicine considerations, which we'll get into in more detail. But in most transactions, this is a little bit of a debate. And the important things to know is that asset deals are more buyer friendly from a liability perspective. I think most lawyers understand that fundamentally, because the buyer is going to avoid inheriting liabilities, and especially in a healthcare deal, that's going to exclude a lot of liabilities related to the anti-kickback statute, Stark, and the False Claims Act, which ultimately get isolated in the seller entity. And on top of that, it's also important to understand the tax differences, because an asset transaction is more beneficial to buyers from a tax perspective, because the buyer gets the benefit of what's called a step up in basis of the assets. This allows the buyer's basis to step up to the purchase price, and then they get to depreciate that over the next, near-term period, and get a ton of tax savings in the first few years that follow the sale. And now, to make it even more complicated, there are also ways to structure equity transactions as asset transactions for tax purposes. And if we can find a way to do that, buyer gets the benefit of that step up in basis. They might have to concede something on the liability piece. But the kind of final consideration I have on here are just the smoothness of closing, which is when you buy the stock of the target, we often minimize a lot of the third-party consents or other kind of hurdles to closing, because the buyer is just stepping into the shoes of the stockholder, and we don't have to actually assign all the contracts to the business, whether that's a lease, a payer contract, or anything else you can think of. So ultimately, a lot of what we land on in private equity deals are going to be stock purchases structured as asset deals. But for our purposes, and specifically in the healthcare space, we tend to see at this platform company establishment level, we see a lot more asset deals. But maybe when the private equity firm flips the asset, it'll be much easier to structure that as an equity purchase. All right, the next thing we lock in on the term sheet is a purchase price. The way this is typically stated in a term sheet is that we state the valuation of the company as a multiple of EBITDA, with such valuation being made on a cash-free, debt-free basis. So there's a ton to unpack there. Importantly, EBITDA is a measure of it's kind of a neutral measure of profitability, and the valuation of the company is going to be tied to a multiple of that. The multiple can vary based on the industry, the type of practice, whether the target has ASCs or not, and most importantly, the size of the practice. Bigger practices that are already scaled tend to command higher multiples. And then on a cash-free, debt-free basis is important. If there's any cash in the bank account, sellers get credit for that. If there's any indebtedness of the company, sellers have to pay that off before closing, or it adjusts the purchase price at closing. And then we establish what's called a normalized level of working capital, and we have a set of working capital adjustment mechanisms in the purchase agreement. So once we establish that kind of top line valuation, what we want to do in the LOI is also break that up. And private equity tends to have three main components in how they pay their consideration. There's cash at closing, 1, 2, an earnout, and 3, rollover equity. So each of these pieces is a little more complicated in healthcare transactions. So for example, that this top line purchase price, we have a constraint that it has to be fair market value if we're purchasing the practice from physicians. That's for regulatory reasons. Earnouts and other contingent payments that are tied to profit are also more complicated because we have to start to think about AKS and Stark. And then Raquel here can talk about some of the considerations and how we structure rollovers where physicians ultimately might own a piece of a private equity backed platform.
Yeah, so in this deal, Heartland Capital is allowing the practice and specifically its physician owners to roll over a portion of the purchase price into the buyer's business. So in lieu of additional cash at closing, the seller physicians will get equity in the business post-closing. And the benefits in the healthcare space of rollover equity are similar to those in other industries and also sort of more beneficial too, given the, how physicians are. So, or given that physicians, are the business that's being bought, and really like the interest and the buyer has in the business is keeping these physicians invested in the business post-closing. And so rollover equity is one way to accomplish that. Also, as we'll discuss throughout the presentation, several states have laws either prohibiting non-competes for physicians tied to their employment or restricting the permissible scope of non-competes for physicians tied to their employment. And we're also seeing a trend now among various states further limiting the permissible scope of physician non-competes. So rollover equity is an additional tool that private equity can use to incentivize physicians to stay with the practice post-closing in lieu of non-competes. And as outside counsel, we will draft the transaction documents in a way that subjects the rollover equity for each physician owner to repurchase rights post-closing that are triggered in the event the physician leaves before a certain time period, usually called bad leaver clauses. So if they leave without cause or if they're terminated with cause, they would forfeit, or the value of their rollover equity would be less than it otherwise would be had they left on like quote unquote good terms. And just to note, I know Nathan hit on this a little bit. Rollover equity in healthcare transactions has to comply with the complex regulatory landscape, restricting financial arrangements tied directly or indirectly to referrals or patient volume. So as healthcare counsel to Heartland Capital, we will want to make sure that the rollover equity is structured in a manner compliant with healthcare regulations such as Stark and anti-kickback statute. We'll also note that it can be difficult to value rollover equity in the healthcare services space. There's some market uncertainty around the changes that are happening in the way we pay for healthcare. And then, as Nathan said, there's also fair market value requirements. And the last point I'll make on this is, well, not necessarily the case here with our transaction because the physicians are actually excited to partner with Heartland Capital. Physicians tend to be more independent, have strong preferences towards self-employment, and often are only selling their practice in anticipation of retiring in the near future. So this second bite of the apple approach with rollover equity may be less appealing in many physician transactions. And in order to get the bid, the buyer may have to make an all-cash offer.
All right, and then one of the other big pieces that we need to discuss in an LOI, especially if it's a competitive one, is what are we doing about the risk allocation and indemnification obligations of the seller? So a fundamental question here is, what is the seller going to be responsible for as it relates to liabilities of the business post-closing when they no longer own the business? It used to be in any transaction, we had an indemnification or a holdback and kept about, call it 10, 15% of the proceeds back from the seller as security for any obligation, any issues that came up post-closing. In today, especially in non-healthcare issues and especially in the especially in non-healthcare spaces and especially in private equity, but increasingly in the healthcare space, deals are insured by a third party. So rather than hold back that amount of money, we go buy an insurance policy and we can split the cost with the seller. We could offer to buy all of it. It depends very much on kind of the positions of leverage. But if we assume seller has a competitive process here, a good M&A advisor, they're going to be asking for a commitment to get a rep and warranty insurance policy, and they're going to ask the buyer to pay for it. So this can speed up a deal because there's less negotiation about reps and warranties between the buyer and the seller because we have a third party underwriting that risk. But as advisors to the buyer, we also got to be, aware of what that might require. So, if there are, private equity firms out there who, might not do have a full legal diligence process that results in a large memo. You're going to need to do that in a healthcare transaction because the underwriters are relying on the buyer's due diligence. So the client's kind of risk tolerance on legal issues can sometimes be a little different. It might create a little more work, even if it speeds things up with the seller. So it's important to kind of understand exactly what the insurer is going to be looking for. And often you can engage insurers at this LOI stage to look at the deal and give you a sense of that. And the market in insurance is currently pretty soft. So we are seeing more insurers get comfortable with, maybe a red flags report instead of a full-fledged due diligence memo. But it's good to kind of get that feedback at this stage before we commit to purchasing a policy and going through the steps of underwriting a policy.
So as I've already mentioned, the value of cardiology associates to Heartline Capital is primarily in the physician services. So Heartline Capital will need to determine which of the 12 physicians are quote unquote key physicians that need to sign employment agreements as a closing condition. And Heartline Capital will want to make sure the key physicians are referenced in the LOI. The LOI can also include the basic non-compete terms that will apply to the physician owners of the practice in consideration for Heartline Capital's purchase of the goodwill and going concern value of the practice, and the scope of this non-compete in some respects can often exceed the scope of non-competes tied to employment under state law, with the caveat being that like these non-competes will be effective for a set time period post-closing, while the employment non-competes will be effective for all of employment plus some time period thereafter. And then for some of the key physicians who are not owners of the practice, but whose continued employment is material to Heartline Capital's decision to purchase the practice, Heartline Capital is going to pay them a transaction bonus in order to extend the scope of the non-competes to those physicians. And then lastly, the LOI will want to include some of the more gatekeeping closing conditions. So it depending on how you structure the deal, you know, there may be required third-party payer consent, there may be required, you know, Medicaid, Medicare consent. Same for licenses, permits, such as CLIA amendments and accreditations for the use of imaging equipment. And then, you know, as outside counsel, part of our role is going to be to help determine what consents, notices, approvals, et cetera, are going to be required based on the transaction structure.
All right, so now we've got the LOI signed, and Heartline has a binding exclusivity period. This could be 60 days, could be 90, 120 days, might have some auto renewals, but Heartline has the confidence that the seller is no longer negotiating with other potential buyers, and the key upshot there is it's time for them to start investing real time and money in their confirmatory due diligence, legal, financial, operational, regulatory, you name it. Now you're going to start to see the client engage more outside advisors and specialists, knowing that if they spend that money on third parties, they're much more likely to get a deal done with this buyer. So the first thing I'll talk about is well, I have a secret word. Today's first secret word is health. Please select the correct answer from the choices below. Again, today's secret word is health. All right. Now I'm going to talk about financial due diligence. So Heartline did some initial financial due diligence before the LOI was signed, because they obviously need a basic understanding of those financials to arrive at a purchase price. But what they've looked at are financial statements, projections, tax returns, all of which were prepared by the seller. Now the LOI has been signed. Heartline is going to engage usually a third-party accounting firm to do an independent review of those numbers, and that's usually called the quality of earnings review. And it's important to understand, I think, even though lawyers can sometimes be very uninvolved at this stage, because the client kind of gets the LOI signed to say, okay, we're not really gonna you know, start spending money on lawyers until we get through the financial due diligence. I think it's still important to understand what is going on here as a lawyer. So if you remember, we went through those purchase price assumptions, and the transaction top line valuation is based on a multiple of EBITDA of 8.5x. What that means at this stage, in kind of the most simple terms, is if that EBITDA is $500,000 short of projections, that means that's a $4.5 million issue because of the multiple. So, this is why this is the first due diligence that buyers want to do. It's because a $500,000 issue here is gets magnified by the multiple that the transaction's based on. And it's also why sometimes you turn up, a $1 million issue in legal due diligence, and that's not as important to the buyer because that's probably a one-time expense. So they can just, reduce the purchase price by $1 million, or they can, agree to split the issue with the seller, and find a solution there. If there's an issue of a much smaller magnitude in the financial due diligence, because that actually affects the profitability of the business, that is something that is really going to change the financials around a deal. So I say this is important for legal advisors to understand, because it can inform a lot of potential revisions to the structure of the transaction. So, for example, we have, let's say we have this $500,000 issue. We think the EBITDA is closer to $4.5 million than what the seller previously stated, which was $5 million. Common solution there is we're going to pay you cash at close based on that $4.5 million of EBITDA that we found in our quality of earnings report. And if next year you can hit $5 million, we'll structure an earnout so that you can get that money in a year after you kind of prove that these issues that we caught on the diligence report are not going to be recurring. And then, of course, that brings in other regulatory questions, which we talked about a little. But it's important to understand kind of how the upshot of that financial due diligence affects the deal. It affects the timing of the transaction, and ultimately can affect the structure of the deal and require an amendment to the LOI, or a very different kind of payment structure than might have been contemplated at the LOI stage.
Okay, so for the purposes of this 1 hour long presentation, I won't go over necessarily every single healthcare due diligence item you'd want to look into, but I'll highlight some of the priority items. And so first thing is that Heartline Capital will have hired a third party to conduct a billing and coding audit for, claims to third party payers. And to the extent an overpayment is discovered, they'll want to work with the practice to get ahead of it and self-disclose the overpayment to avoid potential excessive fines or penalties. Heartline Capital uses a sophisticated third-party billing and coding auditor who has, in the context of several other transactions, identified overpayments resulting in self-disclosures, which is a trend we're seeing with sophisticated private equity healthcare transactions. And this shows actually one of the benefits to the government and other third-party payers of private equity in the healthcare M&A space, and also the benefits of increased M&A activity with sophisticated buyers generally is just that we're getting, self-disclosures out of these transactions. And then to preview our discussion on indemnities later, any identified overpayment as well as any other healthcare liabilities will be included as special indemnities with no cap or time limit. So thorough diligence is key to protecting Heartline Capital against any unknown healthcare liabilities. And then the healthcare due diligence process will also involve, if not already done during the LOI phase, finalizing a third-party fair market value opinion for the purchase price. For fraud and abuse due diligence, as we've mentioned already, Stark and the anti-kickback statute are the main laws in play here. And this is where Healthcare Regulatory Counsel is going to be instrumental. Just to give an example, Cardiology Associates does in-house lab work. So Stark is definitely implicated by these actions. And as Healthcare Counsel, we will want to make sure they have structured their ownership and compensation relationships to fit within a Stark exception, such as the in-office ancillary services exception. And then from an anti-kickback statute perspective, as Healthcare Counsel, we will want to request, agreements with referral sources, marketing arrangements, any co-insurance waiver policies, any policies or practices involving the provision of free or discounted services to patients, or any services offered as a courtesy to staff and their families. And, that's not necessarily going to be an anti-kickback statute violation, but we would just want to make sure Healthcare Counsel is reviewing that and making sure everything looks all right. And then for like a 12 physician group like Cardiology Associates, we're not expecting a compliance plan as thorough as we'd expect for a hospital or a health system, but we would definitely look at their compliance policies and plan for the essentials. We would also want to confirm that the practice has established policies for exclusion screening to confirm no providers are excluded from participating in federal healthcare programs. If there's any licenses and permits required to be maintained by Cardiology Associates, we would want to make sure that those are all up to date. None of those have lapsed. And then also look into, again, depending on the transaction structure, any change of ownership requirements for those permits. And then lastly, for healthcare due diligence, for HIPAA diligence, we would look at HIPAA policies and procedures, HIPAA training for the practices, physicians, and other providers and staff. And we would also review any potential and reported breaches and security incidents.
All right, and then to briefly touch on some other areas of legal due diligence we do in any transaction, we ask for all the organizational documents of the seller. For if this target is a C Corp, so those are going to be bylaws, articles of incorporation, maybe there's a shareholders agreement. If the target's an LLC, there might be an operating agreement instead of those documents. And we're primarily reviewing these to answer some really kind of fundamental questions. One, who has the authority to sell this business, and are we making sure that everyone who needs to sign off on this deal is signing off on this deal as we negotiate it? And we also want to understand if there's any historical, what I'll call cap table risks. So are there prior owners? Were they properly bought out? The last thing we want is for, when we, cut a check for, multiple millions of dollars. Last thing we want is for some prior owner to come out of the woodwork and say, hey, I wasn't properly bought out and I'm entitled to some of those proceeds that you sent to one of my former partners. Then we get our labor deployment team in there to look at some of those issues. Common issue, especially around founder-owned businesses, is how they classify employees. Do you have an independent contractor who's really an employee? That can create legal liability, both potential claims from the service provider there, but also the IRS or various state departments of revenue might take issue with the fact that the company that we're buying has not been properly withholding taxes. So we got to get our arms around that liability. Checking every contract that we're assigning here, or if it's a stock deal, whether they have change control provisions, seeing if we need landlord or other third party consents. And then we're going to take a look at all their benefit plans, make sure there's no liabilities there. All right, so now let's say the quality of earnings is complete. We're typically at a stage where legal due diligence is almost complete. We've done kind of an initial pass at everything we asked for on our checklist. But financials got a full green light. That report's been finalized, and we've got, close to a green light. Stuff that we can kind of tie up while we negotiate documentation. And then as part of documentation, there's going to be a lot of, there's going to be a lot of reps and warranties in this purchase agreement that might start to flush out some other legal diligence issues. So the legal diligence never really ends until the minute we close, but we're at a very comfortable point. And so now is the time where a buyer says to lawyers, we feel really good that this is going to get done. Go ahead and start drafting all the documents. So the first thing we're drafting is the purchase agreement. That's the main agreement regarding the sale of the business. It's the legal backbone of the transaction. It outlines all the other documents that might be signed. And I think the most important thing to understand when we're drafting that document is what kind of structure we're using. So Raquel's going to talk a little bit about corporate practice of medicine and how those structures are typically set up.
Yeah, so the corporate practice of medicine doctrine plays a big role in separating physician practice acquisitions from other types of private equity transactions. Many states have a corporate practice of medicine doctrine, which prohibits non-physicians from engaging in the practice of medicine. In practice, this translates to a prohibition on non-physicians owning healthcare practices and a prohibition on non-physicians directly employing physicians. Because Cardiology Associates is in a corporate practice of medicine state, Heartline Capital cannot, quote unquote, buy the medical practice. So as outside counsel, we will structure Heartline Capital's investment according to what is referred to as the friendly PC model, PC standing for professional corporation. So either Heartline Capital Partners or an affiliate will act as the management services organization, or MSO, which does not need to be owned by physicians and which will buy the non-clinical assets of the practice and employ all non-clinical staff post-closing. Then a professional corporation, which is wholly owned by a physician who is friendly with Heartline Capital, will buy the clinical assets and employ the clinical staff, which will constitute the physicians and any mid-level providers such as nurse practitioners and physician assistants. The MSO and the PC will then enter into a management services agreement, or MSA, under which Heartline Capital will receive a management fee. Here, the MSO is going to be paid a fixed flat fee. You may also see MSO fees based on the MSO's expenses plus a markup, or in some states, MSO fees based on a percentage of the practice's gross or net revenues. But just be aware that some states prohibit payment of a fee based on a percentage of revenue, which is often referred to as a fee splitting prohibition. And then the MSO fee should generally be fair market value. When it comes to the management services agreement, there's just a couple of items that I wanted to briefly touch on. So due to the variances among state laws when it comes to the corporate practice of medicine doctrine, these agreements may require tailoring for each state. As outside counsel to Heartland Capital, we will ensure the MSA is drafted in compliance with state law. Generally speaking, though, the MSO, cannot have any input over clinical decision making of the PC or any control over the independent medical judgment of its employed physicians and other healthcare providers.
All right, and then the other, obviously another important feature of the purchase agreement is going to be the purchase price mechanics. And what is important to really sync up with the client on here is how exactly the working capital adjustment, all these kind of financial items are going to work. So it's easy to, and we do see this where the buyer's first draft, they just bracket all these terms and say, hey, the business parties are going to figure out what this looks like. I think your client's going to be better served if you have a chance in drafting this agreement to really dive into some of the unique working capital items that are in place for this business, and understand your client's perspective on how to negotiate that. So what's typically going to be set is some kind of peg for working capital, but then there's also a question of what gets excluded from working capital. Cash will be excluded non-controversially, but there are certain items that start to look a little bit like a working capital liability, or a little bit like kind of long-term indebtedness. And as buyer, that makes a huge difference, because if it's treated as working capital and subject to the peg, there's no real purchase price adjustment for that item. But if it's in indebtedness, the purchase price will be reduced for those items. Similarly, you got to understand exactly how EBITDA is calculated with respect to the specific business. If you're drafting an earnout, you're typically going to have some kind of adjusted EBITDA definition with specific add backs for one-time liabilities that you may have seen in their practice. And we talked about transaction bonuses for physicians in states that don't allow non-competes in relation to employment. Those are going to be important to think through here, because those are certainly indebtedness-like items, and we want to make sure any transaction bonus that we have to pay a physician at closing to enforce a non-compete is something that comes out of the seller's piece of the pie here. And then we're also going to get to that sort of fundamental risk allocation function in the purchase agreement. The way that works is we have about 40 pages of statements that the seller makes about their business. These are representations and warranties. They range from very general to very specific. You have sort of fundamental things like we have the authority to enter into this transaction, other than set forth on the disclosure schedules. There are no other third-party consents that would be required for us to sell this business. Capitalizations, who are the owners of the business. There's going to be reps and warranties about financial statements, the quality of the accounts receivables, the accounts payable. You're going to have, certainly in this deal, some extensive healthcare specific representations as to regulatory compliance, billing and billing accuracy, and you're going to address a whole host of other regulatory issues that apply to every business: employees, real estate, cybersecurity, et cetera. And then what we do is we take these reps and warranties and we group them into regular reps and what we call fundamental reps. And the primary difference there is the survival period and the cap. So for regular reps, typically there's, I'll call it 12 to 24 month period where you can bring a claim related to those. And they'll be subject to a cap, which is typically going to be whatever amount of indemnification escrow or insurance coverage that you have in this deal. And then on the other side, we've got the fundamental reps, the fact that you have the authority to enter into this transaction, some really thorny, healthcare stuff. Those are going to be fundamental, meaning that they survive for longer. They might survive for a statute of limitations period. They might survive for 5 years. That gets negotiated. But more importantly, they're not limited by the insurance policy or the escrow. So if a $10 million issue pops up, as buyer, we're not taking risk on that. That's something we can go back to the sellers on. And then you also have a group of things called special indemnities that are kind of outside the reps and warranties. So if you discover a specific issue, there's a known piece of litigation, there's a known billing and coding issue, we're just going to put a special indemnity in there for that. So it's not going to be limited really in any way like some of the reps and warranties might be. All right, so now let's see how much time we have. We were going to talk about a few potential diligence issues that might play out as you're negotiating this purchase agreement, talk about how we might deal with those in the purchase agreement. We're close to the end here, so if anyone has questions or anything while we go through these, we're also happy to address those. All right, so the first issue we discover is the seller discloses they have an ongoing lawsuit filed by a former clinical director alleging wrongful termination and a breach of an incentive compensation agreement, which would entitle them to a share of the transaction proceeds. The suit is still in its early stages, and the plaintiff is seeking 7 figures in damages. So this is non-controversially a seller issue. The question is that the buyer has in a situation like this is simply, how much do we want to, even if we're doing an asset deal, there's going to be some, messiness that this party could create. For us, as the lawyers on here know, just because a suit is frivolous doesn't mean it doesn't cost us money to deal with it. And just because we have a contract that says the seller is going to be responsible for all our costs related to it, doesn't mean that's going to be easy to enforce or, a good use of anyone's time because, those sellers are also the people running our business. So the two kind of routes here are, one, we can tell the seller, settle this before we close. The seller isn't necessarily going to love that because that gives this former employee a lot of leverage. This former employee in these situations, a lot of times they know the business is for sale. That's why they brought the suit. They know that they can kind of throw a wrench in things and extract more of a settlement than they would if they actually have to, litigate this thing to completion. So that's one route. The other route we could go is we get comfortable with the messiness. We understand, hey, this plaintiff is outside like the realm of reasonableness here, and we don't want to force our seller to deal with that. We're going to get comfortable with the messiness. We're going to do an analysis of this claim. and say, nine times, the plaintiff's asking for $2 million. We think this case would typically settle for 250. So what we're going to do is we're going to set up a special escrow for this, and we're going to put the $2 million in escrow, and that's the seller's money as soon as they settle the case. And so what happens is once they settle the case, any expenses the buyer incurred in dealing with or facilitating that settlement, that's going to come out of the escrow. Obviously, the money that gets paid to the plaintiff comes out of that escrow, and whatever's left over, then the sellers we can release that money to the sellers, and they can take on those proceeds.
Okay, so we've identified another issue. So some of the ways we handle it will be similar to what Nathan said, and then, given the type of issue, a little bit different. So Heartline Capital discovered that several employees identified as nurses and marketing materials are in fact the equivalent of unlicensed medical assistants, and that they've also been performing tasks and services that are required to be done by licensed registered nurses. So, first and foremost, Heartline Capital is going to tell cardiology associates to just stop marketing them like this and stop having them perform these tasks right now. And then they're going to want to get their hands around it, do an analysis similar to, the last slide, to determine what types of liability or exposure for buyer can result from this. So, the medical assistants themselves could be liable for practicing nursing without a license. That's a little less of a concern to the practice. I think what the practice and Heartline Capital could be exposed to is civil liability for any negligence claims that result from this. There is administrative liability for holding out, it violates the license laws too, that the practice has been holding these nurses or these medical assistants out as nurses. And then and also for the tasks that they've been performing, there is potential financial liability related to any claims submitted to third-party payers that, the unlicensed individuals won't have been credentialed and submitted claims under their names, but it's possible that this, the services they provided, and then services related or incident thereto that were billed to Medicare or third-party payers, they were submitted in violation of those rules, and so now they're tainted claims. To the case of Medicare, it could be a false claim. So they would want to look and maybe hire an auditor to look into the potential financial liability there. And then thinking about, going back to the key physicians idea, if any physicians who oversaw this, who approved it, understanding the liability that they could face to their licenses, to their Medicare enrollment numbers, stuff like that, just to understand the full scope of what could come of this. And then as far as non-legal risks go, there's also concern for reputational harm. And so once, Heartline Capital has an auditor, has looked into it, has determined what they think the potential liability could be, which could be difficult here. Similar to the last slide, this will be a special indemnity, and so they will want to withhold a portion of the purchase price and just put that in escrow. It's kind of tough to know when these, any liabilities could surface and fully settle. So it might just be a reasonable length that buyer thinks is sufficient. And then, after the fact, technically seller is still on the hook for it. Although, as Nathan mentioned, it doesn't always work out like that. Another thing I think I would consider here is understanding if any physicians who maybe this was just a mistake and oversight, I didn't know better, to the extent any physicians were doing this knowing it was in violation of the law, I think Heartline Capital is going to hesitate to give them employment offers, and entering into an agreement with the physician who has showed a blatant disregard for healthcare laws. And to the extent it was wide scale, like this could be a deal breaker. But hopefully it was just an honest mistake. And then would be, like Nathan said, also, it could delay closing. It could just be addressed in the purchase agreement. And then
another thing we might do, which is rare, but if this is a significant enough liability and we want to let the sellers deal with it themselves, and we've committed to a stock deal, I've seen deals change over diligence issues where because the issue is so significant, we might switch from a stock deal to an asset deal as another way to kind of get a layer of protection for the buyer, and to isolate a diligence issue like this. Sorry, go ahead, Raquel.
Oh, no, that was a great point. The last thing I actually wanted to say on this, I'm not going to get into it too much because it's a whole nother topic, but to the extent any claims submitted to Medicare and Medicaid are now tainted false claims, the practice is going to want to disclose this before a whistleblower, just to prevent those sort of added fines and penalties. And then that also underscores the need for confidentiality around this issue. And there might be some conversations had around who within Heartline Capital, and more importantly, Cardiology Associates, is even going to be made aware of this issue and part of the team tasked with addressing it. And then, so lastly, and I know we're almost out of time, ancillaries are going to be sort of negotiated with the purchase agreement. Each document's specific to a different part of the transaction, and they can vary by transaction. For this, the remaining minute or so, I'm just going to focus on employment agreements because those are important, given what I've said about the physician services being the main value of the practice. But other things like here, we would have an escrow agreement. We would have here, you might have a transition services agreement if you're going to need time, maybe to transition billing and collection services or migration of patient records into buyer's EMR platform. And then the MSA agreement that I've said. But so for employment agreements, the main things are going to be physician compensation, and this might have been worked out in the LOI and bid period. The non-competes, again, we have various types of non-competes tied to different aspects of the transaction, and you'll just want to make sure those are being done in accordance with state law. And then the term and termination provisions, as I've said earlier, the bad leaver clauses and the rollover equity structure might be tied to with and without cause termination in the employment agreement. So you'll want to tick and tie those together. And then just note, like, if the main terms haven't been decided during the LOI phase, physicians like to negotiate their employment agreements a lot. And so this is definitely something that lawyers and the business team will spend a lot of time negotiating. And then with that, I think, yeah, we're at our second secret word. So today's second secret word is care. Please select the correct answer from the choices below. Again, the second secret word is care. And I'll give everyone about 30 seconds to select care as the second secret word. And then with that, Nathan, I will turn it back to you for any final comments.
Well, I think we're at the end of our time here. If you have any questions, feel free to reach out to Raquel and I. Our contact information is here. Thank you for participating in our webinar. Please complete and submit the survey that we'll display at the conclusion of the slides here. Thank you all.